What's up, everybody, and welcome into a trial. So many people say you have to at least hit the highlights of this. These exchanges between the judge and the prosecutor, the judge and the defense attorneys, witnesses and the prosecutors, witnesses and the defense attorneys and the judge is unlike any other trial that is going on right now in the world, in America, on YouTube, whatever you want to choose. And today we're going to do just that. We're going to go through some of the wilder moments. We've already hit some of them in the past, but there are more in a trial that seems like it is never ending. So we're going to see if anybody's out of line, if anybody's rights are being violated, answer your questions, and get into the comments together to discuss this case, as we'll continue to keep an eye on it as it goes. And if you guys send me video clips like this, we're going to break them down and watch them together. So make sure you hit that like button and subscribe to our page so you don't miss any future videos on the YSL trial. So Law and Crime has picked some of these clips. I'm going to pick some from there. We've already broken down some of them on our YSL playlist if you want to go check them out. Brian Steele and the judges exchange. We broke that down in detail. We have a couple, I think 3 or 4 exchanges we're going to look at here where the judge and the prosecutor just get into it. The defense attorney throws his hat in the ring to fight with the prosecutor and tell the judge he doesn't think he's doing a good enough job handling the prosecutor. Then we have a witness that does something that is a prosecutor's worst nightmare. So we're going to break all that down together now, starting with an exchange between the judge and the prosecutor.
During the course of page two, during the course of over 2 hours of the initial interview, defendant.
So I'm going to just break it down on normal speed because he reads quickly.
Not asked to speak to an attorney. Page 2. During the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more.
That's as unequivocal as it gets, right? We've seen this Miranda discussion and this, whether or not they left any gray area or wiggle room in asking for an attorney. The judge has gotten this one completely right. When they say they don't want to talk no more because they want their attorney, or they say I need to talk to my lawyer before I answer your questions, it's over. Stop asking questions or everything is going to get thrown out. So far, so good with how the judge is handling this situation, because the prosecutor at this point is trying to get into those statements.
That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paldo and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, with respect to the.
So when she said the court, she meant the case law. In the case law, they found that the defendant re-engaged, reinitiated, and started the conversation again. The judge is saying that's not what we have here. I'm not worried about that. He's made his decision. Okay. And I've caught some other parts of this trial, just myself watching and listening to it. And it is a very common theme in this trial for the prosecutor to continue to argue even after she's lost. And sometimes I actually feel like she's won on the second or third argument. It's kind of like with your kids. If I say, Maverick, you're not doing this, and he asks 2, 3, 4 times, and then I end up saying, okay, fine, you can do it. Well, guess what he's going to do next time I say no? He's going to ask 2, 3, 4 times. So as parents and judges, your yeses should be yeses, your no's should be no's. You should stick to them to create discipline and have people act accordingly based on your rulings and your decisions. And if you don't do that, this is what it's going to continue to sound like.
Statements that were made after that time. We do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe. It was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence. And since the state has the burden of proof,
Okay, but I've seen the video at this point in time.
video does not encompass when the defendant actually reinitiated contact.
So there's a video of him saying, no, I don't want to talk to you, not until I get my lawyer. Video goes off. And then, oh, the defendant wants to talk now after the video went off. Well, guess what? Guess what that opens the door to? Coercion, promises, inducement that law enforcement can do off video. I'm not saying that's what happened here, but there's a lot of case law on that. I actually had a case when I was a very young prosecutor. I was prosecuting a DUI case. I got handed the file about 2 days before trial. And before I had ever gotten the case, it was a private defense attorney, a very good defense attorney that I happened to be friends with at the time as well, had filed a motion to suppress a bunch of statements the defendant made and the breath test that the defendant gave. And he blew like a 0.29, which is 3 times the legal limit in Florida of 0.08. So obviously high breath, but it all got suppressed. Why, you may ask? Well, on the police body cam, they asked the defendant, do you want to blow? He said no. Said, okay. They turn off the camera. Then they turn the camera back on and the defendant's like, okay, I'm ready. And he blows. It's like, well, what the heck happened off camera? Well, we don't know because the defendant's not going to testify. He has a right not to. The law enforcement officer at the motion to suppress hearing said, I turned off the camera. The defendant said, well, do you think I should blow? And I said, yeah, I think it could help if you didn't drink anything. And the defendant's like, okay, then I'll blow. Then they turned the camera back on and the defendant blew. And the judge found that it wasn't reasonable enough once the defendant had already made his decision to say no, that off-camera discussion with law enforcement could have the process of feeling like the defendant was coerced or forced to blow, or he could have said something that was not actually, he could make a self-serving statement on the stand, the officer, and lie, potentially, not to say that he did, and it just wasn't reliable enough. What we had was the defendant unequivocally saying no, he doesn't want to blow, therefore it was suppressed, and any statements he made after he said no and they turned off the video, it was all struck, it was all suppressed. Because we don't know what happened off camera, and when they clearly are saying something on camera, camera goes off, we don't want a situation where cops are beating people into submission or things like that, so it was all suppressed. We ended up going to trial, even though it was going to be a tough trial with no blow, and we ended up winning, actually, because the officer's testimony, the driving of the defendant was bad. He denied field sobriety exercises and denied the breath, and the jury ended up convicting him, which I felt good about, obviously, because we knew what his blow was. But you got to do it with the reliable evidence, and the judge didn't find that evidence to be reliable. I find this a very similar situation. He's saying he doesn't want to talk without his lawyer. Video goes off. Then either the video comes back on or there's more testimony that now he re-engages and makes more statements. No, we can't be having that. You've got to continue without that fruit of the poisonous tree.
The problem is he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
They should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin. I think
By the way, this is outside the presence of the jury. I do think this judge's demeanor, we've talked about it in the past, is kind of harsh sometimes and maybe more condescending or disrespectful than he needs to be, but I can also understand he's very frustrated. This case is taking forever. More on that later. But I think he's spot on and right how he's breaking this down. And the state is just absolutely wrong.
you all are just annoyed more so that your detective did something that he probably regrets now. And
That sounded like the judge saying the quiet part out loud. It's like, Judge, you're fighting about it. You're a little annoyed. You're frustrated because your detective screwed up. And now you don't get the evidence that you maybe should have gotten if the detective would have done his job right.
and that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has. Once you initiate your right, or you revoke your right to be examined and have counsel, and to have counsel present at that point in time.
He has said the same thing, which again, I think is the right ruling 3, 4, 5 times at this point. I don't know why he feels like he needs to keep repeating himself. I don't know why we haven't moved on, because the state continues to argue.
the courts are very, let's just say, cautious about reinitiation at that point in time. And at that, you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my rule.
The thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor.
If you've got if you have other evidence independent of this, I'll consider it the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35. Your Honor, Edwards versus Arizona.
Sounds like the same argument she's already made, that he reinitiated.
And Your Honor, this is a 2020 Georgia Supreme Court case. And
Your Honor, at some point, Your Honor,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not.
The other voice you hear is the criminal defense attorney of the person in question that was interrogated. And he is saying, at some point, Judge, you just got to make a call and tell her to stop, and it's over. And now they talk over each other. This literally seems like, I don't know, daytime television, the way that they just talk over each other and fight. It's impossible to make a clean record like this. The court reporter's job is impossible when lawyers act like this. So even if the defense attorney's right in this situation, you just got to stop. You got to let the court reporter go or type. And then you got to say, Judge, when can I have a chance to respond? Let the judge give you your time to respond and then go from there.
Not stop.
Hey.
I was speaking.
Hey, Ms. Lowe, y'all got.
I'm sorry, I was
Both
speaking.
y'all can't talk at the same time.
I know, I was speaking.
By the way, that person telling them to chill is the bailiff. When the bailiff feels like he has to get involved, let me tell you how unusual that is. I've never seen it. I've never seen it in any case I've tried, in any case my dad has tried, where a bailiff has had to get involved between the two lawyers. And again, this gives you an idea of why the judge, I think, is maybe frustrated or condescending or a little snappy or snippy with some of the lawyers, because this would annoy the crap out of me if professional lawyers were continuing to do things like this.
And I expect to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down.
There's the bailiff who's like, you guys got to stop.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
And I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that
Okay,
fact,
no,
but
you
Judge,
don't. No, you don't.
Your Honor, we have just not been able to present the evidence. That
No, you don't. I
state
get it.
has to
I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
Yeah, I couldn't believe that the bailiff had to get involved in that. But look, it is.
Yeah, I agree, but he did. And again, that's incredibly unusual. All right, we're going to jump ahead to the defense's response here.
Continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer. He invoked his right to not speak anymore. And I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
And he's right. That's absolutely correct. You can't just continue to argue and continue to argue after you've lost. I get being annoyed. I get making a record. And she had the opportunity to do that. But it really has to stop at some point, or you're just literally wasting everybody's time. Okay, so yeah, we skipped through Steele when he had that argument about, the court disrespecting him. And we skipped through the witness that was high on the witness stand because we've already broken down those clips. But there's a couple more clips here at the end. And Jesse Weber here, whose show it is going to set up some of the clips so we can get context, so we can all be on the same page when we hear what actually happens in the courtroom.
In fact, this person didn't come to court at first, defied a subpoena that she says she never received. So this witness was allegedly the victim of an armed robbery back in 2013, reportedly involving Mr. Williams, which is apparently not in the indictment. But Prosecutor Love told Judge Glanville that she has spoken with the witness several times about the court needing to hear her testimony, and said that the witness indicated she did not want to come to court. So she ended up telling Love that she was in the hospital, couldn't come in, but the DA's office says that officers found her at home, actually arrested her on a material witness warrant. But if the prosecution expected her to be particularly cooperative once she was on the stand, or to give some bombshell incriminating testimony against the defense, they were wrong.
Learned after asking that it was a.
So this is a prosecutor's worst nightmare. A witness you think is going to show up, answer questions. And we've seen this in, I think it was the YNW Melly case, where they called somebody and was like, yeah, that didn't go how you expected it. Well, this isn't going to go how they wanted to either. And frankly, it goes so poorly for them that I think there's an argument they shouldn't have even been allowed to ask these questions and put these facts in front of the jury if the witness was just going to say no to all of them. Now, the reason they're allowed to is they have a reasonable belief and a reasonable basis that the questions they're asking are true. And especially if it's based on prior testimony or prior investigations where law enforcement said she was going to say this, or this was her statement before, then they're allowed to ask those questions and make them part of the case, because the jury hears it, even though what the lawyers say are not evidence. When the lawyer puts a fact in their question, the jury hears it. And if the lawyer is sarcastic enough or argues in closing, she said no to all those questions, but very clearly, I think she was scared on the stand or making things up or whatever it may be. So when these questions are heard by the jury and there's facts in them, we've got to handle those delicately and make sure there's a reasonable belief or reasonable basis to even ask those questions.
Friend of your child's father, known to you as Thug, who was at the door.
No,
Do you recall telling the police that you opened the door and let Thug inside your home?
no,
Did you ever say to the police that Thug's brother was also with him?
no,
And do you recall telling the police that you turned your back on Thug's brother, and a person you called DK after letting them in your home?
no,
So she couldn't just make all that stuff up and ask those questions. Like, I can't call somebody to the witness stand and say, didn't you actually do this? If I don't have some reasonable basis for believing that, or other evidence or whatever it may be. Sounds like they have another statement where this witness made those statements. That's why they're allowed to ask those questions.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
no,
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
no. And my baby didn't even drink bottles. My baby was breastfed. So no.
She's like, you're so far off that my baby didn't even drink bottles. So how could I have gone? Why would I have gone to make a bottle for my baby? Now, is that true? I don't know. But it definitely adds some legitimacy to her statements that this is just all wrong, what you're saying. I don't know. Is the jury going to buy it? Have they packed on enough bad facts for everybody involved in this YSL trial that everybody's just going to get convicted because they're generally bad guys? Or is the state's presentation so clunky, and this being such a swing and a miss from the state, especially once we hear how cross-examination goes, that maybe they're actually losing this case?
Did you tell the police that the two suspects, along that Thug, his brother, and DK demanded money from you and your gun?
No.
Not a lot to say there. Well, the following day, AB was cross-examined by Keith Adams. This is another member of Williams' defense team. Listen to this bombshell that was dropped.
You were asked some questions by the Assistant District Attorney, Ms. Love. Is that right?
Yes.
You remember her asking you at one point, are you afraid of Jeffrey Williams? You remember that question?
Yes.
And then she may not have said Jeffrey Williams. She may have said, are you afraid of Thug? You remember that?
Yes.
Okay. And your answer was no. Is that right?
Yes.
You have no reason and
This is a
had
friendly witness. Again, it's cross-examination, so it's really dangerous when you give a lawyer a friendly witness that they can cross-examine. Now, you tell me, does it sound like the defense lawyers prepped this witness and talked to this witness? To me, I think the answer is yes. And when we get into this, bombshell that she drops, if you watch the YNW Melly trial and you've watched some other trials, it's not that unusual for witnesses to say things like this. And especially in these kinds of cases where there are so much going on and maybe people trying to do a favor, do a solid, or get on the good side of one of the defendants or whatever because of their power or position, that these kind of stories seem to come just front and center during the trial to really discredit the investigation, law enforcement, state attorney's office. And that's exactly what this cross does.
no reason to be afraid of Jeffrey Williams. Is that right?
No, I don't.
Okay. In fact, when you testified yesterday, you were on edge. Is that fair to say?
Yes.
You didn't want to be here.
Yes.
And part of it is because of the interactions, and your reaction yesterday was based on the interactions you had, not with Mr. Williams or anyone over here, but with the district attorney's office. Isn't that true?
Yes.
That's not good for the state, right? Now, do they go too far with this witness? Do they make her seem too good for them? Will the jury start to think she's a coached witness or she's too friendly for the defense? That's something defense attorneys really have to think about before they get such a friendly witness who's willing to basically testify positively exactly how they want her to, that she's not afraid of the defense. She's afraid of the prosecution. She had to be arrested and dragged here.
You told us when you were back there that they had been, quote, harassing you for a number of months. Is that true?
Yes.
And in fact, you said that prior to coming out and testifying, that the only person you were afraid of, you didn't want to be around, was Investigator Hamilton from the district attorney's office. Is that true?
Yes.
So this is the bombshell, right? Her allegations against Investigator Hamilton, not Young Thug, not any of the YSL defendants, but the investigator on the case. So what's the bombshell? Why is she afraid of him?
Mr. Hamilton had contacted you prior to yesterday. Is that right?
Yes.
Mr. Hamilton had harassed you. Is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you. True?
Yes.
You felt like, and you told us, that you were really concerned about coming out here.
I'm going to object as to relevance.
I'm overruled objection.
So first off, he said something there. You told us. So this witness told the defense team about these allegations of abuse. The state objects to relevance. It's like it's very relevant if the investigators are harassing and abusing and trying to force witnesses to do things that are witnesses for the prosecution. I know it sounds like this is a witness for the defense, but the prosecutor forced this witness to show up and testify. An investigator shouldn't be harassing witnesses and scaring witnesses so they're so afraid so they come and testify and say something good for the prosecution, even though, of course, this witness didn't do that, but it's absolutely relevant. Police misconduct is almost always relevant.
You told us that the times when he would contact you, it seemed like he was trying to date you.
Yes.
He wanted to meet you, supposedly to talk about the case,
Yes.
but you didn't feel comfortable going to meet him by yourself.
Nope.
Because you didn't feel comfortable going to meet him by yourself, you brought your 20-year-old son with you.
Yes.
Was that before or after you met with Mr. Hamilton and he told you, don't talk to nobody else?
That was after. He told me before that. I came in, I seen Miss Love, And that's when I told y'all yesterday that me and Miss Love, we only discussed for a brief because they was like trying to tip me.
Quite the revelation.
They were trying to either tip her or tempt her. And again, the allegations are one thing, but what this could do is shine a light that, is this what they did with all the witnesses? Is this how they handled their investigation? Did they force witnesses to do things? Did they harass them until they testified for them in the state? Is that how they flipped, tipped, tempted witnesses into saying things that were positive for the state and negative or against YSL? Very interesting, because this is something that could color the whole investigation, not just this one witness. And to have this evidence as the defense is huge. But we've seen it before. We've seen it in other cases. We've seen these kinds of allegations in other cases, and it doesn't often work. And I feel like sometimes it's a bit of overreaching for some of these witnesses, or feeling like they're trying too hard to help the defense, and then the jury ends up thinking they might be biased. And we don't have jurors saying that, but eventually when they dismiss what witnesses like to say and they end up convicting the defendant, it doesn't turn out to be as big of evidence as it could be, but it's definitely better than not having it, right?
Revelation, right? Well, AB was back on the stand again a few days later and explained more about her accusations against Investigator Hamilton as the defense showed text messages on a large screen.
Now, how about the next one? That same night, Wednesday, February 7th, 6.
Well, this certainly legitimizes her claims. Good morning, Mama. Hope you slept well. Again, don't come at 1:30. I have a feeling the defense will keep this same witness from yesterday all day again today. I'll give you an update at 3 p.m. You will most likely go up tomorrow. Call me, please. Call me one more time. Then I'm out of your hair for the night. Hit me up if you're bored later. We're not going to talk shop. So the good morning, Mama part, not great or professional. Hit me up if you're bored later. We're not going to talk shop. Definitely corroborates her feeling that he wanted to date her. So when you start to legitimize a witness's testimony like this and give it more credibility, now, it's not quite the abuse maybe that she's stating or to that level. So the jury can still find she pressed a little bit, but this definitely is more than just, hey, can you come give me your statement? If you want to testify, great. If you don't, great.
6:45 p.m., where he says, hit me up if you're bored later. We're not going to talk shop. Remember that text message?
Yes.
Did you talk to him later on?
Yes.
Did y'all talk shop?
Yes.
What do you want to talk about?
Going out.
Going out? Going out as in walking out the door, or going out on a date?
A date.
And this is February 7th of 2024, this year, when the investigator for the DA's office is supposed to be talking to you about a case. But in
You
fact,
also got to be really careful, and I almost mentioned this before, as we see, different defendants that they're showing, smirking like this, also probably not a great thing. If the jury's watching and it's like, haha, yeah, we got this witness on our side, you don't want him to think that. Now, if he's just smirking because this investigator is trying to take this girl out on a date, and that's embarrassing for the investigator, I get it. But you always have to worry about your mannerisms, what you're saying, what your face is doing when you're a criminal defendant in a case like this. And the juror's eyes at any moment could be on you. They could obviously be on the witness and the lawyer, but we always tell our clients in these situations, in any trial, the jury is going to be watching you. So know that.
is calling you, talking to you about going out on a date. Is that true?
Yes.
Did the fact that this employee of the district attorney's office was trying to date you come into your mind as you're thinking about whether you have to come in here and testify or not?
Yes.
This is really not a great look for the Fulton County District Attorney's Office, to say the least. But the drama did not end there. No, another big witness in this case, called by the state, was Walter Murphy. And he took the stand on April 10th. And to give you a little bit of idea who we're talking about. So Murphy, also known as DK, he took a plea deal in which he entered a guilty plea to a charge of conspiracy to commit RICO, and he would be required to testify in this trial. Another important witness for the prosecution, right? Murphy, childhood friends with Williams, who he knew as Lil Jeff, but he says after he got sent to prison, he and Williams didn't reconnect.
What is your current relationship with Mr. Williams?
I don't have a relationship with him.
When did that relationship cease?
It never ceased. It's just I went to prison.
And while you were in prison, you did not maintain your relationship or friendship?
When you in prison, you don't retain no relationship. All that in.
So again, this is clearly a witness the state's calling to get some information across, which they did because I watched more of his testimony, but not a friendly witness, not somebody that's really there to help them. They've got to pull, it's just like pulling teeth to get facts and information out of some of these witnesses for the state. And usually that's not a good recipe, but that's also something that makes it take a lot longer than you expect.
And since you got out of prison, did you not rekindle your friendship when you got out of prison?
I had more important relationships to worry about than friends. Like my kids.
Prosecution asked Murphy about some of his tweets from 2012 that included terms used by gangs, including the tendency to change the letter C to the letter B, and like this when he was
25th, 2012. Can you read that tweet on August 25th, 2012?
That's the song.
Okay, what does it say?
It's been a long time coming, baby. I just called to see how you been doing lately.
Now, you just said it's been a long time coming.
He even reads it with the C.
Or a B or a C there for coming?
To be.
Okay. Why would you tweet it as a B?
It's just what I was doing right then. I did a lot of stuff without meaning or purpose. I was childish, young, dumb.
again not really giving the prosecution.
And what else is tough about that, though, while Jesse's right, he's not giving the prosecutor a lot to work with. These are the types of things that the trier of fact, which is the jury who's not trained to really do this, right? But they're just using their common sense, their eyes and their ears. They have to figure out. Does this make it more likely that this is a criminal street gang RICO enterprise, that people are willing to take the stand and do stuff like this and try to explain away or take the defense's side, even though they're a prosecution witness? Or is it all just something the prosecution's trying to force? And these witnesses are telling the truth and they're actually helping the defense. These are the types of things that jurors have to work through. And it can be really, really hard, which is why context is important. And a lot of witnesses kind of get canceled out. And there are a few points or pieces of evidence that jurors usually hold on to and stick to, which is why closing arguments in this case are going to be so difficult, number one. But number two, so important to highlight the most important and best evidence or points for your case.
Prosecution what they needed. What did prosecutors do? Well, they walked Murphy through his plea deal and what he admitted in those documents. Murphy is allegedly a co-founder of YSL, which he formed around 2012.
Did you ever create a group called YSL?
A group, yeah.
Okay. Was it something else besides a group?
Not to my means of knowledge.
And what does number 1 say?
YSL, otherwise known as Young Slime Life, began as a neighborhood group but evolved into a gang.
Okay. And did you initial number 1?
So he admits that YSL started as a group and eventually became a gang. And so if he wasn't going to give him a bunch of stuff, he signed a plea agreement admitting that it did eventually become a gang, which again is something they're trying to prove throughout this trial. So I think pretty good piece of evidence by the state, even though this witness was difficult for them.
Yeah.
Those are your initials, right?
Yeah.
Okay. So when I just asked you, was YSL a gang? Why did you tell me you don't know? Did you not acknowledge that in this document?
Yeah, but it say evolve. I don't know when it evolved into a gang. I know when When we made it, it was a neighborhood group. It was
Right.
a group of guys from the neighborhood. I made it a music group.
And in this acknowledgement that you initialed, you said it evolved into a gang. That's what you initialed.
Yeah.
Okay. So
I don't
YSL,
know.
Again, he's not trying to give her much, but he can't really argue with the fact that in his plea deal, and you don't want to go back on that and violate anything or have them rebring charges or perjury or anything like that. So he's like, yeah, I don't know when. It wasn't created like that. When I created it, it was a group of guys from the neighborhood and, we did music, but eventually it evolved into a gang. He doesn't know when. Maybe Young Thug had nothing to do with it being a gang either. Maybe it's become a gang now during trial. Who the heck knows? Obviously not, since he signed this plea agreement before. But interesting kind of wiggling by some witnesses.
I don't know when it evolved into a game, though.
I didn't ask you when. I just asked you, did YSL become a gang?
Yeah.
All right.
And that would happen a lot, him being confronted with statements he made to law enforcement or the state versus what he's saying or maybe not saying on the stand about what he knows regarding YSL, Young Thug, and others. He was on the stand under direct examination for a couple of days, cross-examined by the defense attorneys. That started on Friday with more cross expected on Monday. And that brings us to something that we know you're all thinking. Is this trial ever going to end? It is a fair question to ask. Well, the defense attorneys, they're certainly worried about the pace and the sheer number of witnesses left to go. So far, they've made it through the testimony of about 40 witnesses.
We are losing our jurors. We are losing our jurors. I look over there at them and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out.
In fact, Doug Weinstein, who represents co-defendant Diamante Kendrick, I mentioned it before, filed a motion back in March to put a limit on the number of witnesses that will be called. Well, Judge Euro Glanville is none too happy with the pace of this trial. And even
so one of the big questions is, how do you deal with this? Right? And the defense attorney is like, limit the state's witnesses. We saw other judges that limit defense cross-examination. But it's a very common problem to have trials that take too long. And we've talked about it before in other videos. What are the major issues with that? Well, like the defense lawyer said, you lose the jury. Okay. The jury thought it was going to be a 3-month trial, 6-month trial, whatever, and it's going to end up lasting a year. They're going to lose their jobs. They're going to lose families. Or not lose families, going to have it affect their family. Are they going to miss trips, whatever it may be? That's bad. And they're going to be pissed off and they're not going to like that they're here. Who are they going to take that out on? And is that going to become an appellate issue? Are they sleeping during trial? Do we have enough alternates? The jury is the number one issue. Witnesses. Are witnesses going to forget things? Are they going to watch the trial? The longer it lasts and is streamed, is it more likely a witness is going to violate the rule of sequestration? The lawyers. The defense lawyers have jobs, at least some of them that are private defense attorneys. They have other clients, other things to do, offices to run. It's not fair for the state to make a 3-month trial a 12-month trial. They said 3 months, judge, hold them to 3 months, whatever it was. I can't remember if it's like 3 or 6 months, but I think it's absolutely within the judge's purview to hold the state to the amount of time they said it was going to take. Of course, a little leeway if witnesses are being difficult or not showing up or breaks they've had to take. I get it, but not just doubling the time with no restrictions. Or the judge has an interesting suggestion here that I have heard judges threaten or say that they've done it in the past. I've never had a judge threaten it in a trial I've done.
Suggested he might have a remedy that not everybody would be excited about.
I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I do have.
Yeah, and I don't blame him. And I actually think that's a decent remedy. As miserable as I would be, I would hate it. I would hate it so much. Saturdays and Sundays. Now you're taking lawyers out of their family. It sucks. But to get the case tried, protect the criminal defendant's rights, you're taking the jurors away too. Maybe they'll just handle like motions and stuff some Saturdays and Sundays. While I think it's a decent suggestion, I would hate it. I would absolutely hate it myself. But again, he's trying to put pressure on them to keep it moving, keep the train on the tracks, and move this trial. And it does seem like a lot of things have happened between the parties that could have made this easier and kept it on the tracks. Also, this is another interesting point about severing trials versus trying them all together. Sometimes I'm not so sure. I mean, obviously, trying this case 3, 4, 5, 6 times would be very difficult. But with this many defendants and this many lawyers and this many arguments and this many objections, you see it's not always economically efficient to try all the cases at once. I understand why they do it, and I think it was the right decision, but sometimes it can really blow up in your face.
I have power of contempt. I don't want to use that. I don't. But it's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case to try the best case you have.
The judge ordered the prosecution to provide him with an updated witness list, which seems now to have been whittled down to 150. But to be fair about that, that's down from around 700 at the start of this trial. Just remember that. That's just for the prosecution's case, by the way. Not even who the 6 defendants want to call.
I do have some concerns about 120 days of trial time. That's going to take almost 4 months. And, I'll remind the state, you told me, or Ms. Hilton told me, it's going to take about 6 months.
6 months.
At this rate, it's going to be 12 months. And that doesn't include anything that the defense may choose to. I mean, I'm concerned about your case in chief at this point in time. The defense will present whatever they wish to do with, and I'll deal with it. We'll deal with it accordingly. But,
we were trying to be finished by June, frankly, as I told the court earlier.
yes.
We can't control cross-examination, and that has extended our estimation of the time that we've
And
spent.
that is fair. 1 cross versus up to 6 crosses makes a big difference. But again, you knew that was going to be part of this trial, so you definitely should not have assumed 1 cross. But I can understand how it's hard to guess how long 6 crosses is going to take for 100 plus witnesses.
Well, like I said, if you disclose things, if you don't disclose everything, and we don't disclose things timely, then then what I'm doing is I'm taking up more time. What I want to do is I don't want us to take up 2, 3 hours. I can't do that anymore. So I'm telling you, you need to make very sure that you've disclosed the evidence and you'll be able to tell me what day you did, because if you can't, I'm gonna exclude it. That's my remedy at this point in time.
We will see, of course, if the court is.
So he's saying, if you guys don't handle the rules appropriately in discovery and turning stuff over when you should, and motions compel have to be filed, I'm just going to start excluding stuff. And he even mentioned contempt. If you're not following the rules of discovery, maybe I'll hold you in contempt. Those are more appropriate. And then if there are major evidentiary arguments that need to be had, then I think that's appropriate for Saturday and Sunday. I would not want to bring the jury in Saturday and Sunday, but if the lawyers have stuff to argue about, let's have a 5-hour motion hearing on Saturday. See how quick it is then. See if you guys start resolving some of your issues then. So not great. And the judge feels it, the jury feels it, the lawyers feel it, everybody feels the delay and drag and how miserable it is. And that's something nobody wants. So, this trial is abnormal. It is frustrating to watch. It is taking forever, which is exactly what all of you have been saying to me as well. And that's the same feeling I get when I watch this trial. It has made for some interesting comments and exchanges and some wild moments and highlights or lowlights, depending on how you look at it. So feel free to keep sending me clips, what you guys find. And once in a while, we'll hop in on that trial, see how things are going, see if we're getting any closer to ending the state's case in chief and seeing what the defendants put on as evidence, if anything, as they have no burden in that case. But am I glad Sue Jassa tagged me in this before the video went out so that we could get a reaction and see, was the judge bluffing, or was he really going to come down hard with that remedy that if you guys don't deal with it, work it out ahead of time in a timely manner like you've been doing this entire time, which is causing all these delays and all these arguments outside the jury, would he really exclude evidence? Would he really sanction and punish these lawyers in a way that's appropriate to force them to play ball, work together, get your issues taken care of before we waste the jury's time, so the judge isn't having to waste time with all these arguments and hearings over and over again, making calls before something actually gets to the jury? Will the judge make the call? Will the lawyers call his bluff? Will they continue to act this way? Well, guess what? before this video ends, we got a new clip of exactly that. The lawyers continue to do what they've been doing this entire case, but will the judge change his tune? Will he actually? And when I say sanction, it doesn't mean throw somebody in jail or fine them. A sanction or remedy for misconduct can be exclusion of evidence, because that hurts your client or the state that you represent. So let's take a listen.
Okay, so I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded.
So there was an evidentiary dispute. Lawyers are supposed to talk about that. If something changes, you got to talk about it, give them a timely opportunity to respond, see if they need to do something, if they need to enter something, call a witness, ask another witness about this, if something major has changed. And the judge has said, if you don't do it in a timely manner, I'm going to exclude it. And guess what? This is the first opportunity to my knowledge that it's come up. And what does he do? Excludes it. And guess what? I think he's good. I don't think this is going to be an appellate issue because he gave them warning after warning and they still did it. Now, if this was like literally the smoking gun, probably going to come in anyway. But for this evidence, he says, no. Let's see if the state can continue to argue even after the judge has made a ruling once again and see if she can change the judge's mind.
The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that. And I'm going to exclude.
He does literally treat them like children, which is a little annoying in my opinion. But again, I get it because this is very annoying from a judge's perspective.
The PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
All right.
let's be real clear. We are not going to introduce this PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
So it's 2 sections she wanted in. Defense said he didn't know about them until this morning, I believe she said. Too late. Either you can work weekends or I'm going to exclude this stuff. A weekend work isn't going to fix this problem. So what's the judge do? He's going to exclude it. And let's see if this starts to tighten up the trial. But again, more argument from the state.
Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, and you, no, well, Mr. Sharp's got objections to it.
Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection
No.
at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then.
I get what the state's saying. So now if a piece of evidence is going to be entered tomorrow, can the defense just object at midnight? And if we don't talk about it before the morning, how do we deal with that? So that makes a lot of sense too. Now, most cases, I don't know if they did in this case, you have an exhibit list. You turn it over to the other side. The other side says which ones they're going to object to. In civil trials, it's a lot cleaner, a lot easier. Criminal trial stuff pops up. New exhibits are added. But if you're going to add them, you got to give them enough time to make their objection. If they're objecting at the last minute and not doing anything until the last minute, I think the judge is going to hammer them as well.
Summon our juries, please. Summon our juries.
And he says, summon our juries. Cutting her off. He's heard enough.
Have a seat, madam. Have a seat. You better exclude it. And next time, make sure you're prepared.
The finger wag. I mean, there's a lot of, he has had it up to here, as they say.
Make sure you're prepared next time. I'm not going to do this anymore. I'm just not.
If this was the first time, this was the first issue, I would be hammering this judge. Like, you can't do this. You got to give some leeway. You got to have some grace. But honestly, with the other clips that we've watched throughout this trial that's going months and months and months and months, he's had enough and he's got to do things to move it along. And he's got to make sure this is fair. This is not trial by ambush. You can't spring things on criminal defendants. You can't spring things on the state. That's not how this is going to work. It's already happened multiple times and caused other delays. In order to keep it from being a trial by ambush, what do? You stop, You have a hearing, you let the defense argue, you let the state argue, the judge makes a call, it comes in or it doesn't come in. But he doesn't want to continue doing that, wasting all this time when lawyers are supposed to be prepared, supposed to have stuff ready ahead of time and have these discussions and arguments ahead of time to either come to an agreement or let the judge know with ample notice of an issue that you have with an exhibit that might come in so the judge can make a call. Usually you don't want stuff like this happen. This should be a last resort. This should not be the first thing a judge does.
We are starting right now, it's 1:20. So
We have talked to them. We have said we don't agree.
then file a motion and get it before me and we'll take it up. Both of you all have equal.
So he did backtrack a little. Sounds like she can file a motion now, set some hearing time, maybe on a Saturday, and maybe it can come in later. So again, he's trying to make it fair. He's trying to give them options. But right now, she's not going to spring it on them when they just spoke about it this morning. And again, he's ticked because they've wasted more hours.
Responsibility to do that.
Information they are seeking.
Oh, it's going to be inadmissible right now.
She's like, it's not admissible. He goes, it is now. I don't really care what's in it. I'm excluding it just because you're not following the rules. And again, this is a sanction you can give for discovery or trial testimony that's not timely produced or discussed or issues aren't resolved like they should be. Now, is he taking it too far? Maybe. I don't know exactly all the details around this exhibit, but maybe she'll have the opportunity to file a motion, have it heard, and bring it in later. Now, it could cause witness issues and more delays, but he at least left that door at least cracked open.
You said to file a motion. There's nothing.
I'm not gonna have any more discussion about this, madam. I'm not. I don't. Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
So the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared,
I like that line. Prior preparation prevents poor performance. And I do think that this is one of those, you remember all the crap a friend has done to you to tick you off and that you don't like. And it's like, you've done this a million times. That's it. It's over. It's like, this wasn't that big of a deal. It's like, well, maybe this one wasn't, but all the other ones before pile on top and we got to talk about it now. We got to handle this. So maybe that's what he's saying is maybe this issue is not as big of a deal, but in conjunction with everything else, he's had enough.
That's why I sent them what I sent them last week, a whole week and a half ago.
I mean, it really seems crazy if she did send it to them a week and a half ago or 2 weeks ago, tried to call them twice and they never talked to her until this morning or they didn't file an objection until midnight. That seems totally unfair. I don't know if that's the truth, but that's what she's throwing out there to try to continue arguing it.
Oh, 2 weeks.
I'm not. Well,
And I said I would like to discuss.
our jury's coming in, madam. Our jury's coming in. Have a seat.
And if you didn't have a seat there and continue to fight and argue, that could create a mistrial, which she nor anyone else in that courtroom wants to happen. And that was it. Wow. So they called the judge's bluff and he does exactly what he said he was going to do, which I think is good on him, trying something different. The definition of insanity is doing the same thing over and over again, expecting a different result. So if he was just going to keep allowing them to fight and delay and spring stuff on each other and not act professionally, both sides, not just the state, both sides have been accused of doing this. The judge has reprimanded and been angry at both sides for doing this. And he said, enough's enough. I'm changing the way I do business. And the fact that he did it and excluded it, everybody in that courtroom is on notice that that's how things are going to be handled going forward. So, wow. I appreciate you guys sending me these clips and tagging me in these clips because you choose the content. So make sure you hit that like button. Make sure you subscribe to our page. Follow us on all social media accounts at Tragos Law, at lawyer, and send me this stuff because we're popping in and out of this trial. And when the highlights or lowlights come about that you guys want a reaction and a breakdown to, I've been watching some of it on my own as well and not necessarily doing all these reactions. But when you guys send me some of these clips, it is wild. It's unlike anything I've seen. It's so different from any case I've tried. It is wild. And just as a little reminder, severing cases sometimes can make them go quicker because this definitely isn't the quickest and easiest way to get it done. But I can't wait to hear what you guys think. Let me know in the comments and in the live chat if you have any questions or other clips that you think I need to take a look at in this trial. But for now, that's all I got. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.